So I will divide my talk into three parts. I'll try to finish at 8 o'clock because my train is 9:30, St. Pancras. I will try to go ASAP. So first we got to understand the concept of a will as compared to wasiyyah. It's a confusion in our community. I want to highlight that. Then, what's the legal requirement? Because we're living in UK. You've got to follow the law of the land as well. If you have a will, what the law of UK requires from you when you draft a will. And finally, I'm going to hint at some important clauses that you can consider, provisions in your will as a Muslim. So, part one, the difference between a will and a wasiyyah. What is a will? Lawyers, don't answer, please. What is a will? Any idea? What is a will?
Miras.
No, miras, inheritance.
Well, it's something you have it, like garai, money, treasure, gold.
What you want. Will is what your wishes are. Essentially, when you pass away, what you want to do with your wealth or whatever you leave behind.
One important word is missing in there, according to the Wills Act. It should be written. There are some exceptions for sailors and soldiers. It is a written expression, that is what you want. A written expression of the testator, that is a person who writes the will, the man. If it's a woman, you call it testatrix. It is the written expression of a testator or testatrix regarding how he or she wishes his estate, that is, whatever he has, his house, his gold, his cash, or whatever, be distributed after his or her death. After his or her death. So that document is so important. If somebody plays with it, it's a criminal offense under UK law. You can end up in jail with that. It's not an ordinary document. Because we know cases where the children, the will is not in their favor, they destroy the will. There are cases like this. So we want to be very careful when it comes to a will. So a will is a written expression, what you want, your wish, what to do with your estate after your death. So only after your death it will have an implication. All right? So why do we need an Islamic will? Wasiyyah is not will. We'll come to that later on. Why do we need Islamic will?
Because in UK you can lose maybe 80% of your head. There is a percentage the bank have to take, the government have to take from you.
Inheritance tax.
Yeah,
That is, it's Islamic or non-Islamic, you will have to pay. That's it. Even you got a will, under certain circumstance, you will still have to pay. But the will can mitigate it, yes.
Yeah, no, it's important to have Islamic will because otherwise the land of the law will apply.
Yeah. Yes, the law of the land will apply. And I'm going to give you a few examples for you to think how serious it is from a Sharia point of view. Now, reasons for having a will, number one, the statistics. The tendency in UK, according to the ONS, that is Office of National Statistics, you can go online, you check it, 70% plus minus of the British in general, not Muslim, in general in this country, do not have a will. And when you look at the case laws in the High Court, it has tripled compared to maybe 10 years ago. More and more people are going to court and fight when we are not clear what to do with our estate after our death. So statistics are there to prove either our family will fight or people don't even have it. Okay. Number two, once you have a will, you can protect your heirs. The government, the probate officer will say, okay, that is right, you go. You are protecting them. Number 3, for example, we know many cases when there is no will, the children take everything and the mother is left like this. There are so many cases come to me like this. Number 3, if we don't have a will, and this is very, very, very serious now, there are approximately 35 verses in Surah An-Nisa dealing with the law of inheritance. The probability is, if you don't take the necessary precaution with that, you will be violating those verses of the Quran. And Allah says in the Quran, after He has given all the directives, Tilka hududullah. These are the boundaries set by Allah. We are not supposed to go outside those boundaries. So a will empowers us to implement those ahkam of Allah. It facilitates the winding up of the estate via an appointed executor. So when you die, you have a will, your lawyer will send it to the probate office. The probate office will say, okay, there is an executor. An executor is the person who will collate all your assets and make sure it's being distributed, etc. When you do not appoint one, it will delay the distribution of your estate. Because now you got to apply to the court to appoint one, and that will take time. So instead of 3 months, maybe you wait 12 months, maybe more. That is now causing problems in the family. Why? One of the problems you're going to have is when you die, your assets are frozen. Listen to me properly. Your assets are frozen. You can't touch it. The executor will have to collate it. If you do not make provision for your wife, for example, she might not. There are some provisions in law. You're complicating their life to access the money you got in the bank. So it will facilitate all those things. So even your asset is frozen, you can make some provision for your wife to get some money. For example, during her iddat, for example, she will need money, right? Number 5, you can use your will for tax exemption. The way you plan, what I said earlier on, estate tax planning. This is a very specialized area. I'm not to talk about it today. Very important, if you have minors, many people don't realize, listen to me properly, brothers, the upper guardian of your children, you are not the upper guardian of your children. It is a judge of the High Court, not you. Under the law of UK, you are not the upper guardian of your child. It's the High Court. So if you die, you got minors. You can appoint through your will. There are academic papers on that. There's no time to go through those details. You can appoint who can be the guardian of your children. Why this is important? Under Sharia, if the mother dies, the nanny looks after the baby. If the nanny is not here, the sister of the wife, it is a matriarchal line, the female who look after that, is quite well entrenched in fiqh. Okay? If you don't do that, the court will look at the best interest of the child, which is not exactly what Sharia is asking. Right? So you got an opportunity through your will, if you got minors, to mention, if I die, so and so, my sister or my mother or whatever will look after my child. That you can put in a will as well. An opportunity to make a wasiyyah. Wasiyyah means a bequest under English law. A bequest. That is, you got to differentiate between inheritance. Inheritance is what the law says you will get. Bequest is you decide. Sharia gives you up to 1/3 of the value of the estate to give to whoever you wish, provided that person is not an existing heir. You cannot make wasiyat for your wife, for your son, for your daughter, for your spouse. You can't do that because they're already heirs. But suppose you had an auntie who was looking after you when you were small. You want to make a small gift for her, provision for her in her old age. That is where this 1/3 comes in. Or you want to set up an orphanage, or you want to give money to this masjid. That 1/3, you can use it to do those things. Or you never perform Hajj. There is outstanding zakat. This is where this 1/3 is being used. If you don't have a will, this cannot be implemented. This is why it's important to have a will. Next one is an opportunity to make a sadaqatul jariyah. That is, after you die, your book of deeds are closed. But Sharia allows you, through the Wasiyyah, even you died, your book doesn't close. For example, you set up an orphanage. Example, you set up a well in a desert country. You set up a Darul Uloom. You sponsor a Hafiz al-Quran. All these things are sadaqatul jariyah. Through your will, you can set up all those things. Even you die, your book of deeds continue. So don't forget to have your will. Not one. Pay your debt. Many times people don't care about their debt. Brothers, the hadith of Rasulullah is very serious about debt. If you have a debt, you don't make the necessary precaution to pay for it. You don't want to pay it. You're careless with it. In the qabr, that debt will rotate around the head. And you don't know when it's Qiyamah. So if you're going to stay 1,000 years in your qabr, 2,000 years, 5,000 years in your qabr, and your debt is turning around your head, what's going to happen? Rasulullah sallallahu alayhi wa sallam, there was a Sahabi. Rasul went in front to perform Salatul Janazah. And he said he got a debt. Somebody said yes. Rasul said, I'm not going to perform Salatul Janazah. Somebody had to pay that debt. Then one Sahabi took responsibility to pay for that debt. So don't underestimate. Many of us are having credit card. I'm not going to the halal and haram of credit card here. That's another story altogether. I'm not to go into those details, right? People think I've got 55 days to pay my credit card. Then I pay 30, if I don't pay, then that's under 20, 30%, whatever the rate of interest is. It's a debt. You got a mortgage. It's a debt. If you're a businessman, you have creditors, it's a debt. All these you got to prepare, make sure that those debts are met, and do not expect your wife to know who you owe. Do not expect your children to know. So what you do that, you have to a codicil, you call it a codicil. It's like an annex you put with your will. I so and so I owe. And you got to revise it every year. Right? It's very serious. Next one is avoid unnecessary litigation in courts. If you don't have a will, probability is, if you haven't given proper tarbiyat to the children, it will end up in court. You got lawyers sitting there, he knows what I'm talking. I'm a lawyer, I know what I'm talking, and there are other lawyers. If you don't have a will, I would say 80%, your children will fight if the tarbiyat has not been made. So when you have a will, it's done, it's clear cut there, provided the will satisfies the law of UK, right? So these are the reasons why we need to have a will. So if there is no will, what happens? If there is no will, then the law of UK will apply. We call that the rule of intestacy. We call it the rule of intestacy. So when a person dies, right, without leaving a will, the rule of intestacy means that the law of UK will apply. You cannot do whatever you want with your estate after your death, right? So even if someone makes a will, listen to me properly, even you left a will, and if this will is legally wrong, the court will reject it, then too the law of intestacy will apply, right? So we got to be very careful. So what is the implication of intestacy? That is when you don't have a will. Under English law, So because you have no will now, Sharia will have no place into that. So under English law, only the spouses who are court married, listen to me properly, I know what I'm saying. You have, some people are making only nikah. Nikah is not recognized in this country. There was a case, appellate division, in 2018, Khan versus Akhtar. The High Court says, nikah is not even a marriage. Understand what I'm saying? So, up to you, you want to be court married, not court married, that's something else. But, under English law, there is a concept called freedom of testation. That is, you are free to give to whoever you want your estate, provided you don't have certain duty towards others. I'll come to that later. So make sure that you have a will. If not, the law of intestacy will apply. What does that mean? I'll give you an example. Sorry, before that, you can see that cohabitees, that is, you have no nikah, they will treat you as cohabitees, not like husband and wife. Cohabitees, if you are not court married. Or no, in a civil partnership, can't inherit under the rules of intestacy. Your wife will not be inheriting if you do not have a will. She's not recognized as your wife under English law. So mere nikah is not recognized under English law. I give you the case law, it is available on Google. Please go and read to confirm yourself that what I'm saying is the right thing. Next, please. Let me give an example. Mr. Junaid is court married to Miss Kulsum in 1890. He's married, court married. Then he made a nikah with Miss Zulekha, and under Pakistani law, he went to Pakistan, he got married, and under Pakistan, nikah is recognized as a civil marriage, just like here. Then, in the year 2000, he got Josh again, he wanted to get married again. He married Miss Fatima according to Islamic law only in UK. So, married Kulsum, court married, Zulekha, Pakistani law is recognized in Pakistan. Number 3, Miss Fatima, only nikah. Last week he had a heart attack. He cannot handle 3 wives. He got a heart attack. Suddenly he passed away without a will. Tell me who will get what under English law now? Think of it. Kulsum will get it. And what about Zulekha, the civil marriage? It is recognized in Pakistan.
If he has any wealth in Pakistan, he will get it, otherwise no.
Under English law, I gave a legal opinion on that recently. If you have bigamy, it falls under the law of felony. It's 7 years jail. 7 years. So those who got wife in Pakistan or whatever, civil marriage, be careful, right? So that is the law of UK. If it is only nikah, no problem. If it is a court marriage, it's a problem. Ajib call, but this is a law, right? You can have mistress, no problem. Na'udhu billah min dhalik. But the moment it's a court marriage, now we're sitting with problem, right? Okay. So you are right. Zulekha will not, under English law, it will be problematic. If he brings it to court, it will fall under, I think this act is 1357, something like this. It's an old act of parliament that governs this type of thing. All right. Okay, is that okay? Do you see, if you don't have a will, what happened? Islamically, how it should be, if it was Islam? 1/8 should be divided among the 3 wives. So at least it's guaranteed. Okay. Now let's continue. If there are surviving children.
Sorry, the question is, so if there is a will, and that is according to Islam, does English law would allow it to be a legal will to be executed?
Yes, there is a concept called, it must not be against public policy, contra bona mores. It must not be.
No, in this case, I mean, if it is to be 1/8 to go to
Yes,
each
under freedom of
wives.
gestation.
Okay.
Yes,
But
usually
then,
under freedom
in a
of
way, are you not
gestation, the
declaring
court
that
will
you had
uphold
three
it.
wives?
Sorry?
So in a way, are you not declaring, are you not disclosing the fact that you had 3 wives?
No, that's what I'm saying. The moment you're going to declare you got 3 wives, you're going to have a problem.
Exactly that. So,
Yeah.
so
They will tell you it's against the public no, public interest. Yeah. You're shooting yourself in the foot.
Exactly.
So you got to find other ways.
Right.
So Islamically, yes. Law of England, no. Kulsum is the one who is court married, the one recognized. If you bring the Pakistani one here, I'm afraid it will fall under felony, and you can end up in jail with that. Yeah. All right. Okay. The other one is only nikah, it's not recognized, so there is no will. She can't go to court. She's not recognized. Right? Of course, you can go and discuss the whole debate about common law wife and so on. I don't want to go into detail. As a general rule, it's no. So interesting in the case of intestacy, if there are surviving children, grandchildren or great-grandchildren of the person who died, and the estate value, listen to me properly, is more than 270,000, right? 270,000, the spouse will inherit. What she will get? The spouse, again, the wife who will get, not your children. The wife comes first, your spouse comes first, or your husband, or the personal property belongings of the person who has died. If it is less than 270, she gets everything, or he gets everything. If there is anything left, you will give 270,000, first 270,000, and what is remaining she gets, or he gets half of it. I repeat, if a person dies, if it is 270,000, the worth of the estate, the spouse gets it. If it is above 270, he will take or she will take 270,000. What is left, half of it will go to that spouse. Do you understand?
Yeah.
That is the law if there is no will.
Sorry, the other half then goes to the state.
No, we come to that. Here's an example. Farooq was in a civil marriage with Zainab. Brother Farooq got married to Zainab. How there is no Farooq here, right? They adopted a daughter called Halima. Okay. Farooq had a brother called Rashid. Farooq died intestate. His estate was worth 450,000. So definitely you can see here, it's above the 270,000. Determine who receives what amount under English law of intestacy. So he didn't leave a will. He had his wife, Zainab, he's married, court married with her, a brother and an adopted daughter. Who gets what? Remember the rule of 270,000 and the half. Very easy, think about it. Okay. Half, the remaining half, what happens? To who it goes? This is a question that you ask. It goes to Halima, the adopted son under English law. Alright? Is that okay? She got the 270,000. What is remaining? Half. She gets half of it, 90,000. The remaining 90,000 goes to Halima, the adopted daughter. Under English law, adoption is jais. The brother will not get.
So if Halima was not the adopted child, but the real child, it would still be the same.
Yeah. And law of adoption is very strict in the UK. It's like your biological child. So, now, what happened? Next page. If you were to distribute that Islamically, compare it now. What would have happened? So 450,000. Islamically, the wife gets how much?
1/8.
1/8. Halima gets how much?
Nothing.
Nothing, because it's not a biological child. It's an adopted child. Farooq gets how much?
1.
Farooq is formed under the residuary. He gets everything.
Because there is no
The brother.
child.
All right? Do you see the complicated contrast? Big, big difference. Okay? So this is what we are trying to say. That
in the Islamic will, if the person leaves something for the adopted child,
1/3. Maximum you can leave is 1/3. Yes. Yeah.
that has to be
Yeah. So do you see the contrast? Intestacy and Islamic law. If you
We
agree.
do, Sheikh. The question here is, if the will is to be according to Islamic laws, in this example, will that be an honorable will in the law? So,
If there is no objection, yes, you got freedom of testation. If there are objections
objection
from the wife, for example, any will can be challenged. I will give you example later on, where the father specifically disinherited her daughter. The daughter won £200,000.
And also,
It's
please
217
elaborate
case law.
if the
Appeal.
brother Farouk, his brother was in the UK or elsewhere, would that make a difference?
Now the law of domicile comes into play now to decide whether you can get it or so on. Yeah. Okay. We are assuming he's in UK. So when you don't have a will, these are the disadvantages, as you can see. It's longer to process the dissolution of the state. It can be 9 months, go 2 years. You got no choice on executor, as I mentioned. You don't know who will be the court who will appoint it, who will be the trustee in case you want to make a trust for your children who are minors. You don't know who are the beneficiaries, who will be the guardian of your children. All these the court will have to decide. It becomes problematic. Then, of course, the longer it is, the longer, the higher is the legal cost. And these are not a small amount. If you are to go to an executor, to a lawyer, on average, those who specialize in dissolution of state, who are step members, that is Society of Trust and State Planners, it's approximately 2%. So if you have 1 million, they will take 2% of it to execute that will. Yeah, understand all the things. There are cost implications. So you got to take all the things into account. Then suit is, in certain countries, the executor must give a guarantee, the same amount of the, like in South Africa, for example, where I practice, there are some rules on that, right? So we got to be very, very careful that we don't leave this world without a will. All right, next please. Now, when you are married, with, of course, with your wife, you are married, there are 2 ways you can decide about your estate. One is joint tenancy. Joint tenancy is like this. For example, I got £50, right? So whatever it is, where is it now? I don't have my email. It's finished. Yeah. It means that this money, every part of that is co-owned. I cannot stay it and say, so half, no. So when I die, this whole 20 goes to my wife. That is joint tenancy. Is that clear? Tenancy in common, you say, no, you can't stay it. 20% for your wife, 80% for you, or 50-50, or whatever ratio you want to make it. The difference is, one is a rule of survivorship. That is, whoever survives, the property automatically goes to the other one, number one. Number two, in the case of tenancy in common, you will have to realize that with the person who dies, automatically it does not go, his share does not go to the other party, it goes in his inheritance. In joint tenancy, it does not go in inheritance. In tenancy in common, it will go in inheritance. So, to be on the safe side, if you're worried about this, you make tenancy in common. But however, if you have a mortgage, then it becomes a bit complicated. So that we discuss with your lawyer. I'm not going to advise it here, right? Is it okay? Tenancy in common and joint tenancy between you and your wife when you buy a house or business or whatever, right? Make sure about the things. So if you got a business, does not mean your wife got half of your business. No. You got to look now, the business, a limited liability company, you must see how much shares she got, how much a share you got. It's a different game. I'm talking, for example, you buy a house. Your attorney, your solicitor will ask you how you want the house to be. Joint tenancy or tenancy in common. This is how it goes in practice. All right? This is where I ask this question, do we have a matrimonial regime in Islam? My humble reading, no. As we understand it in UK, in France, and many other jurisdictions. And the advice I give clients, if you really love your wife or you love your husband, and you want to make it half-half, you can make a shirkatul inam. That is, it will give the effect of joint tenancy. It can be half-half, it can be 40, 60, you decide, provided it is properly drafted, and I would advise you to have it notarized by a notary so that it got legal effect, right? And make sure you sign it, and very, very, very important, there is no undue influence. Tomorrow you die, somebody must not say there was undue influence, somebody forced you to sign it, therefore this document is not valid. So make sure all those precautions are taken. Yeah. I'm mentioning one technical term here, lawyers know what I'm talking here. These are very serious issue in our community. For example, very common in UK, and I'm sure you have read it in the newspaper. A person is in an old age home, care home. After his death, everybody got the shock. The nurse who got everything. The nurse who was looking after him who got everything. How? It is undue influence or not. So now the family will sue and say, no, this will is not valid. There was undue influence of the nurse on him. He was a patient, he was suffering. You understand? So undue influence, these are things that we see. I'm sure you have read it in the newspaper, right? So we got to be very careful. So when you and your wife are working together to bring up a home, to develop the common home, to send the children to the university, to pay the mortgage, to pay the bills, this is a pure reality of UK. The average person, husband and wives are working. Illa mashallah. Those who are well off, those who are very pious don't want to go and work. But the reality is in UK, husband and wife are working to make the house run. That's the reality. Right? A person working in a factory, brothers, how much is getting? 10 hours, £10 an hour, approximately. Yeah. Work it out. Your rental is 1,000 something, maybe 1,500 for 2 rooms. Yes. How on earth you made the end? And tomorrow you're telling me the wife got nothing? You follow what I'm trying to say? This needs to be sorted out while you're still alive with your wife. And vice versa. Not after death and then children and wife, children and father are fighting. So this needs to be attended while we're still alive. Right? There are so many cases in court on that. Believe me, right? Maybe you don't know about it. Those who are in the field know what we are talking of, right? Okay, next. Reza and Amina are court married and own their flat jointly as beneficial joint tenants, joint tenancy. They have a child called Salma. Reza dies intestate, leaving the jointly owned flat worth 300,000 and 50,000 in shares in his own name. Determine who receives what amount under English law. What gets how much?
300,000.
270,000.
Plus half of 50.
Then left over 50, yeah, so
And then 25.
275, yeah. And the 50,000, what happens to that? That's not jointly owned.
Shares.
That's
Remember what I said?
half of
She will get, yeah,
half of-
okay. So this is in the UK law, right? So the flat goes automatically to Amina. This leaves an estate of 50,000, which also goes to Amina as it is worth less than 270,000, right? Salma inherits nothing. Even if there was a will, the house will still go to Amina due to the contract of joint tenancy. So automatically, because of joint tenancy, she gets it. Rule of survivorship, right? You understand? Because it's joint tenancy, she gets it. So this 50,000 is less than 270,000. It's a different contract, she gets it. And the girl gets nothing. Now, suppose you want to do it Islamically. Forget about joint tenancy now. 300,000 plus 50,000, that's made 350,000. The wife gets how much? 1/8. The daughter? There is no son. She gets half. Now, 1/8 plus 1/2 is how much? 1/8 and a half, 16, 8, 9. 9 over 16. So we're left with 16 minus 9. 7 over 16. What happened to the 7 over 16?
Brothers.
No, there's no brother there. There is a concept in Sharia called, we got the doctrine of return. The doctrine of return says the spouse will not get more than what is specified. But what is left over, you got to recalculate it, send it back to the existing shares beside the spouses. So it will end up with the daughter. All right? There's a mathematical calculation. We're not going to do that there. So the point I'm trying to raise here is to make you think. It's not that easy. Okay, when I die, they decide, the children will decide. It's not like this. Reality is something else. Yeah? They will fight, and then the small Sahab, then Mufti Sahab, and then the Mufti will fight among themselves. You know what I'm trying to say? Because, of course, you will go and get a Mufti who sides with you. Fatwa shopping. You know what I'm trying to say? So this is the reality of things. Yeah? So avoid all those things.
So if you have joint tenancy, couple of properties on joint tenancy,
Yeah.
right? But you're not court married. But because you have joint properties, is that not good enough or sufficient evidence that you are essentially civil partners?
Yeah, joint tenancy doesn't have to do with marriage. Two chartered accountants decide to buy property as they want to. It's joint tenancy.
Which means the survivor.
It falls under law of property.
Okay,
The
which
Property
means
Act, I think, of
the one who
1925.
survives gets it.
Sorry?
The one who survives gets the
Yes.
other.
When you bought it, they tell you the ownership is joint owned, jointly owned. It's got to do with the law of property, not law of marriage. You understand? So we're bringing law of property into marriage. This is why I'm saying, do we have a matrimonial regime in Sharia? If we don't have, we've got to think about it. Because the scenario in Europe is different. I'm not saying to change Sharia, not what I'm saying. We've got to find a solution how to resolve those problems, right? Okay. Now, according to Sharia, because of time, there are so many verses of the Quran which says Allah has decided who receives what. This is in Surah An-Nisa. Unto males shall be a portion of that which their parents and others near of kin may leave for them, and unto females shall be a portion of that which their parents and other near of kin may leave, whether it be small or large, a portion others. This is one verse. Allah tells you it's already determined who receives what you call in continental law mandatory heirship. Like in France, it's the same thing. It's already decided by law, right? In Germany, you go. In UK, it's not like this. You got the freedom of testation. In continental law, in France, only 1/4 you can decide. But the law, the Napoleon Code already decide who gets what. Yeah? So same thing Sharia is telling you, who gets what. It's a different legal system, right? There's nothing to jump. Okay, next. The Hadith of Islam says that learn the law of inheritance, because this will be the first knowledge that will be taken away from my ummah. And as you can see here, everybody is looking at me. When we talk about law of inheritance, we're talking about shares, we get worried. We don't know about it. Most people, 99%, with a conservative figure I'm saying, people don't know about this issue. Right? Then Rasul says the first part of the useful ilm knowledge which will be taken from my ummah will be this, ilm al-faraiz. Then Rasul says, learn the laws of inheritance with the same sincerity as you learn the Holy Quran. This is quoted by Imam Darimi. Then you get another verse of the Quran that says, وَمَنْ يُطِعِ اللَّهَ وَرَسُولَهُ. Whoever follows Allah and His Rasul concerning those matters, يُدْخِلْهُ الْجَنَّاتِ. Allah will make him in Jannah, and to him in Jannah. تَجْرِي مِنْ تَحْتِهَا الْأَنْهَارُ. Under which there will be the flowing rivers. خَالِدِينَ فِيهَا. He will always even remain there in the company of Allah subhanahu wa ta'ala. تِلْكَ حُدُودُ اللَّهِ. These are the parameters set by Allah. وَذَلِكَ الْفَوْزُ الْعَظِيمُ. This is the real success. So if you write a proper will, that can be your Jannah. That can. I'll bring a hadith later on. You will see what I'm saying. Inna Allah kana aliman. Then Allah was a faridata min Allah. This is an order from Allah. Allah says, Aba'ukum wa abna'ukum, your fathers or your sons. لا تدرون أيهم أقرب لكم نفعا. You don't know who will die first and who will benefit from who. Allah has decided that. Because we don't know, we don't have ilmul ghaib. So Allah has put a system there. And this system is so scientific that even the Orientalists like Sir Ramsay, for example, who translated the book of Sirajiyah, he said this is the most sophisticated law of inheritance or succession in the world. Not one. I can give you many Orientalists, professors in universities. The system is so systematically calculated. Okay, then Allah says, whoever disobeys Allah and Rasul and transgress the limit, Allah will enter him in the Jahannam, in the hellfire. He will stay there, and for him there will be a very sharp, serious azab by not obeying the law of inheritance. No, next, please. Now listen to this hadith now. Very important. And Jabir was a Jadilul Qalb Sahabi, great Sahabi. He reports that Rasulullah sallallahu man mata ala wasiyatin. Listen to this, very beautiful. Whoever dies and making a wasiyah, make sure things are distributed, right? Mata ala sabil, he dies on the right path, was sunnah. Wa mata ala tuqa, who makes some precaution he took, right? Was shahada. وَمَاتَ مَغْفُورًا لَهُ. And whoever dies on this state, he dies as a forgiven. This is by Ibn Majah. Next. This hadith, reported by Abu Huraira, the champion of narrators of hadith, he says that, إِنَّ الرَّجُلَ, and listen to this hadith properly, and this is reported by Imam Ahmad and by Ibn Majah as well. Rasulullah says, إِنَّ الرَّجُلَ, a man, verily a man, لَيَعْمَلُ بِعَمَلٍ أَهْلِ الْخَيْرِ. He has been doing a lot of good actions for 70 years. For 70 years, these have been only good actions. Right? But فَإِذَا also, when he started deciding the distribution of the estate, هَافَ فِي وَصِيَّةٍ, he started making nonsense. فَيُخْتَمُ لَهُ بِالشَّرِّ. Allah sealed his action, these 70 years. Allah sealed it, Allah make it seals his action as bad, and Allah will enter him hellfire. وَإِنَّ رَجُلٍ, there is another person. لَيَعْمَلُ بِعَمَلٍ أَهْلِ الشَّرِّ. He's been doing a lot of guna, drinking alcohol, making zina, backbiting, just by. For 70 years he's involved, he's subsumed in guna, in sin. But فَيَعْدِلُ فِي وَصِيَّتِهِ. He makes justice when it comes to distribution of his estate. فَيُخْتَمُ لَهُ بِخَيْرٍ. Allah will seize his action as a person who has been doing good the rest of his life. أَمَلِ فَيُدْخِلُ الْجَنَّةِ. Allah will enter him Jannah. That is the power of observing the law of inheritance through our way. Brother, I'm going to ask you a simple question. Simple question. What are the pillars of Islam? What are the pillars of Islam? Shahada, prayer, Saum, Zakat, Hajj. These are the pillars of Islam. Do we have the law of inheritance there? No. Check the entire Quran. Which law Allah has given more detail? Law of inheritance. Does not that ring in our head, in our ears, the importance of law of inheritance? The detail, law of inheritance is not the pillars of Islam, but the detail Allah has gone in that field is more than Salah, Saum, Zakat, Hajj, Shahada. Why? Question we have to ask. If it is not a pillar, why Allah has given so much detail in the Quran? Because it brings societal equilibrium. It brings societal distribution of wealth. It removes the poor people from poverty into more financial stability. Right? So we have to understand the rich distribution of wealth in Islam. Let me finish the Wasiyyah. Let me finish this Wasiyyah first, yeah? Let me finish the thing you want to. They just say it's a bit too. Is it too heavy for you? You coping? Okay. Okay. Give me 10 more minutes. Yeah. Okay. This was about the will, where it's a written expression of your wishes, how you want your estate to be devolved after your death. Now there's another question called wasiyyah. What is a wasiyyah? A wasiyyah is a bequest. What is the difference? Inheritance is when you die, who will receive what is already decided. That is inheritance. Wasiyyah means from what you got, Allah subhanahu wa ta'ala is giving us a chance up to 1/3 of the value, total, the net value of estate to give to whoever you want, provided it is not an heir. That is what you call in English law a bequest. You call it a bequest. This is why I'm very reluctant to translate wasiyyah as will. A will is a whole entire document. It can contain your wasiyyah. All right? It's not the same thing from my humble opinion. Next. So this one. So you make, go fast. You can make a wasiyyah, for example, during maradul maut. Say, for example, you waive your entire debt and you are a cancer patient. You can't do that. Only 1/3 will go. Somebody owes you debt. You can say, I'm waiving my debt. No, only 1/3 because you're in a maradul maut. You're in a state of terminally ill, as a doctor will call that person. You cannot give 100%. So you can, up to 1/3 you're going to limit it. Payment of fidya for salah, sawm, hajj, outstanding. You owe Allah. So say, for example, the hajj nowadays is costing about 10,000-15,000. But if you cannot exceed more than one, if this 15,000 is more than 1/3 of your estate, you can't do that. You've got to do for another means. Only 1/3 can go to pay your hajj or whatever, your zakat. So you can put it, but that is not inheritance. That will go in this 1/3 to compensate for our shortcomings. Payment of kafara, penalty for violating long oath, fast, and so on. So all this can be paid because you have delayed it, we delayed it, now death is coming. So what to do now? We cannot compensate. So okay, we are going to compensate that financially, and therefore up to 1/3, ulama say, you can do that. This is where wasiyyah is very, very important. How to use it, when to use it. Next.
Sorry, is there any limit for bequest in the UK?
One. No, you can give everything to your dog. People are doing it. They're giving half of the thing to their dog. The law allows it. No problem. Yeah. Okay. Jim.
One question, children under the special guardianship order in the UK law, do they inherit?
If it's your own child, yes.
Not
But then the guardian will have a right to monitor that money because he's a minor. Yeah. Then of course there is the rule of curatorship and so on. That's another rule that comes into position. Yeah, where somebody will manage it for you.
You have a child under the special guardianship order with you, it's not your own child.
Ah,
Do they inherit?
if
Adopted children inherit, as you said earlier. What about that? Is it GO?
under English law, if there is a will, yes. If it is an adopted child, yes. Under English law. Under Sharia, adopted children don't get. You have to make a wasiyyah for them if you want to give them. They are not automatic heirs. Yeah. Okay. Important rules of wasiyyah. We use quickly about this. Legal heirs do not receive wasiyyah. Your wife cannot get your bequest. Your son, your daughter, your spouse cannot get a bequest. They will inherit what the Quran have said or the Sunnah. If amount is more than 1/3, then executor should limit it to 1/3. So if you have exceeded this 1/3, your executor must limit it to this 1/3, unless the heirs consent to it voluntarily. If there is no heir, then the entire estate can be made a wasiyyah. Na'udhu billah min dhalik. The entire family is going in a plane. There's a crash. The whole family is gone. So before you go, you have written it. That in case I got no heirs, I make what you call a residuary gift. I'll come to that later on. If there is no heirs for me, you give it to an orphanage or whatever. Right? Okay. Wasiyyah for non-Muslims is valid. Yes. So many people, for example, in UK, they are married to Ahl Kitab. According to Sharia, the Prophet said, a Muslim will not inherit from a non-Muslim, and a non-Muslim will not inherit. Listen to the word, inherit. But the wasiyyah you can. Okay? In the case of a mixed marriage, all right? Wasiyyah can be revoked, very important. You can make a bequest, you change your mind, you change it. Whereas for inheritance, you cannot change your mind. It's already there. Okay, next. Now, there are 4 types of wasiyyah. One is mandatory, in the sense that you haven't performed your hajj, it was further on you. Make sure you make a provision that people go and make hajj for you. They call it hajj badal. Yeah. Mustahab, at times it's mustahab. For example, your dafan kafan, how you're going to be buried. There is cost involved there, right? Usually this kafan dafan comes from the estate, by the way. People don't understand that, from the deceased state. So this is why we got to make provision for that if we can. Our kafan dafan, because now a qabr costs about £6,000, isn't it? A grave costs about £6,000. Where you got £6,000? Overnight, you know? You got a heart attack, na'uzubillah min dhalik, and you are gone. Who will get £6,000 for you? So we have to make the provision for the things. Yeah. Then jais, make a wasiyat of all things which are permissible, such as who will perform the salatul janazah. You can make a request, so and so. You make a wasiyah. It's not money. It's not monetary, this one. The akabir of the past, their wasiyah was, the will was full of wasiyah, advice to the children. Yeah. Then some are haram. When you make such a wasiyah, which is exceeding 1/3, you call it a bequest. You know the court will implement it, and you are taking the haqq of an heir. That is haram. You can't do that. Okay? So we shall take a